Hi, I'm Chris Cox, and thanks for joining me. Today we're going to talk about wetlands permitting and how it is an important aspect of development property. We've packed a ton of information in the next 60 minutes that is critical to making sure that you know what wetlands and waters are and how to manage your development projects to either avoid them or to be able to plan for impacting them ahead of time. This webinar starts with a basic introduction into wetlands and other waters and how to think about them. We then cover 7 key permitting steps that you never want to miss in your development process. And we then finish up with a few case studies that show you how these steps are put into action. We're going to start with a little exercise here. We posted several photos from our recent projects and asked which one of these photos contains a regulated wetland or other water where modifying or removing it would require a permit. Well, the answer is all of them. They're all regulated, as much as that may be surprising. There are many types of wetlands and other water features, such as streams, lakes, and ponds, that have different characteristics and requirements for what would be considered an impact. Sometimes just your project has to be near enough to a stream or a wetland to need a permit. Additionally, there are 3 levels of government that protect wetlands and other waters, including the federal government, the state government, and the local government, such as your city or county. To make things even more complicated, the definition of waters of the U.S. was updated in 2023 and now excludes waters without a permanent surface connection to a permanent water. This means that sometimes you might need a permit from a state government, but not a federal government, if the wetlands you are impacting are isolated or not connected to a permanent water, such as one that is considered navigable. So why should you care about wetlands permitting at all? If you're a property owner or a developer and you want to improve land in or around a wetland, stream, or other water, you will likely need permits from state and federal agencies. Wetland delineation reports are often therefore required for development permit actions where you submit your application to a local government who regulates how you use your property through zoning and development laws. These local governments also have to follow state and federal laws. So if there is any potential habitat for plant or wildlife species or wetlands that are on your property that might be governed by a federal or state law, then they are going to want you to study it before they will give you an approval. Some people do feel that they can get away with not complying with these laws, but because the federal, Some people do feel that they can get away with not complying with these laws. But because the different agencies communicate with each other, it is not likely a development approval will occur by ignoring or hiding a wetland impact. And if you get caught, you could get fined or pay remediation, which can be expensive. In serious cases, agencies can even bring criminal charges with sentences that include jail time. Laws exist at every level of government, including local, state, and federal, that protect wetlands and other water resources, such as streams, rivers, ponds, and even small drainages if they are connected to larger water features. These laws started with the intention of protecting commercial resources such as fisheries and canals for boating and expanded to include areas for use of recreation. The primary law that protects wetlands and other waters at the federal level is called the U.S. Clean Water Act, and each state also has its own similar law. Since water features are often home to a diverse range of plants and wildlife, additional laws, such as the U.S. Endangered Species Act, have been passed to protect threatened and endangered species in these areas as well. Finally, water features were home to early and Native American and even prehistoric human and wildlife communities that are protected under state and federal laws, such as the National Historic Preservation Act. What triggers a wetlands permit? Wetlands permits are required when a project results in a permanent removal of a wetland or other water, or when temporary construction is needed in either of those features. You could also need a permit for affecting the riparian or vegetated areas around a wetland or a stream. So how do you know if you have a wetland or other water on your property that is regulated by a state or federal law? Well, you can start by reviewing government databases, such as the National Wetlands Inventory, which approximates where wetlands, streams, lakes, ponds, and other water features are located based on aerial photography and government agency data that they collect through permitting. It is not exact, but it does show where water features are approximately, and if it shows a water feature on your property, you will at least need to have documentation to prove that it is not there, or the next step is to hire a biologist certified in wetland delineations to review your property and determine where that line is. A preliminary assessment can be done more quickly than a wetland delineation, which is more technical and time-consuming. So maybe having a biologist come out to your property for a few minutes to take a look around might really help you steer your project in the right direction. You should review all of the results with your biologist and stake out the edges of any water features on your property or associated riparian areas before you do any sort of design or go back to the local government that you're trying to get a permit from. To find out if you need a permit for your project, you can ask a biologist or permitting specialist, such as myself, for a breakdown of each applicable law and review the permit application requirements with them. You then want to compare these requirements with your project, which may require overlaying your site plan on a map of the wetlands and other water features, and then determining where you might have impacts. You can avoid triggering these impacts by planning and designing your development proposal around them. If your project cannot be completed without working in a wetland or a water, review the application requirements and then complete them or hire a consultant as necessary. Make sure to review and complete all construction monitoring and mitigation responsibilities and coordinate with agencies about those timelines. To develop a successful permitting strategy for your project, you want to confirm each required permit and identify all permit requirements as early as possible to avoid redoing the work. This is really the first step in developing a successful permitting strategy. It also is a good idea to prioritize your permitting requirements, as there may be deal breakers that prevent you from moving forward with the project, or mean that it will cost you a lot more money. If you cannot build because you have a wetland on your property, it is best to know where and how big it is first before completing any other expensive work, so you can exit the project with minimum time and resources spent if you need to just let it go. So what will you get out of this webinar? I've broken down my years of experience in obtaining wetlands permits for projects as large as 1,700 acre specific plans and as small as road culverts into 7 easy to understand steps that explain the process, as well as underlying strategies for saving time and money at each stage of the development. This information is not necessarily new or even proprietary, but it does take a lot of practice to fully understand how it works from start to finish, and consultants like me with the expertise are expensive to hire, so you want to make sure that you get the most out of this. We will take our remaining time today to explore each step of this process, including deliverables and strategies, and finally finish with a few case studies. If you already have experience with obtaining land entitlements, our 7-step process will be familiar to you, as all agency approvals essentially ask for information, review, and approve permits in the same way. Consequently, this process coincides with a lot of the things that you need to do for your development approvals from a city or county governments already. For example, our first step in managing wetlands permitting is to pre-screen your project as part of preliminary due diligence. Now, I'm sure that you are already pre-screening for other factors as well, starting with how much money you will make from the project when it is finished. But we'll talk more about that in a minute. The next steps for our process include determining your permit requirements, preparing your development plan, submitting your permit applications, negotiating conditions and mitigation with agencies, completing construction monitoring, and finally, complying with long-term management requirements. First, make sure to review all existing documents related to your property, including any previous entitlements. You may need to file a Freedom of Information Act request with any federal agencies or a public records request with state and local agencies to obtain this information, especially if you do not have these records or do not know. It is important to complete this step if you are assuming that you have approval, because your local government will want proof if you apply for a development permit, and if a state or federal agency learns about unpermitted improvements after you install them, they could penalize you on top of requiring a permit. Such penalties could include removing the improvements or paying higher mitigation fees. On the other hand, you may confirm you already have permits through this exercise, but still may be required to follow certain conditions to complete your improvements. The next step is to conduct preliminary reviews of wetlands and other waters on your property, as well as any associated triggers that might require a permit, such as endangered species or historic resources. A great place to start is Google Earth, believe it or not, or any other source of aerial photos for your property. The best photos would be any recent photos from a drone survey, but any detailed aerial imagery will be a good starting point. Historic imagery is also helpful in looking for hydrology patterns on your property where water is flowing or standing over time as more or less rain is available. Agencies are very careful about not discounting wetlands and other waters just because they dried up for a year or two. So there has to be clear evidence that these features are not on your property. Another indication of water is vegetation. So if we see more heavily vegetated areas on an aerial, it can indicate that there is water present. We recommend involving an experienced wetland delineator in this discussion to confirm your findings and then draw preliminary boundaries around them on a map. In general, if you want to avoid permits, you need to avoid these areas. It's really pretty simple. You will also want to discuss the potential for threatened and endangered species habitat with a biologist. Or, if you are experienced enough, conduct government database searches yourself to determine whether there is a potential and where. Often, agencies require larger setbacks to protect habitat than wetlands or waters, so this could impact your development area. We'll cover this more later. All right, moving on to step 2, determining your permit requirements. Now, once you have committed to your development project, you will likely be putting forward effort towards completing your development permit application with your local city or county. If you have received any sort of checklist for your development permit, it may require you to complete a wetland delineation to identify any potentially regulated wetlands or other waters on your property, along with a biological study to identify potential habitat for threatened and endangered species. These requirements most often come up on undeveloped land rather than properties that have previously been improved. A wetland delineation is a survey conducted according to U.S. Army protocol that defines where the edges of any wetlands or other waters are on your property. Wetland delineation reports are typically accepted for permitting within 5 years of the survey. You will also want to complete a biological study to determine if there is any habitat for threatened or endangered species, as they are often associated with wetted areas. Biological studies should establish clear avoidance measures you will need to follow to ensure that no protected species are affected by your project. Both of these reports should be included in your development application and will be reviewed under the California Environmental Quality Act or the National Environmental Policy Act. Let me start that over again. Both of these reports should be included in your development application and will be reviewed under the California Environmental Quality Act or the National Environmental Policy Act, or both. These documents provide the analysis needed to determine whether the project would impact wetlands or biological resources and provide mitigation instructions if permits are required. If you need these reports for your project, Make sure you obtain the shape files or CAD files of the wetland boundaries, as your engineering team will need them to complete their designs. Similarly, your permitting team will need to quantify these impacts. Your project may require other studies depending on existing and past conditions and what you plan to do with the property. Cultural resources assessments are always required if you are applying for a federal permit to determine whether there are any historic or cultural resources on your property that may be protected under the National Historic Preservation Act. Additionally, your local government will likely conduct a search through state historic records to identify whether historic or culturally sensitive resources have been found near your property and whether there is a possibility that they are in the area of your development. In California, historic and cultural resources are protected under the California Environmental Quality Act, or CEQA, if there is a possibility that they are protected under state or federal law. Another report that may be required on your property is an arborist report. An arborist report may be required if your property has trees and your project is expected to impact or remove them. Commercial trees such as ponderosa pine and tamarack are considered commercial trees and require a permit from CAL FIRE or a similar agency to remove. Other trees such as oaks in California are considered native and often are protected under city or county ordinance as well as CEQA. Trees typically need to be a certain size to be protected, usually 6 inches or larger in diameter at breast height. You may also need a topographic map of your property to prepare improvement plans for new buildings or roads, but this information is also very useful for identifying existing conditions such as slopes and drainage patterns and either proving or disproving hydrologic connectivity between surface water bodies, therefore identifying wetlands. If you are applying for a city or a county for a development permit, chances are you also have a plan or have a boundary survey completed by a licensed surveyor to establish or confirm your property boundaries. These boundaries are also important when reviewing wetlands or other water features, as they may actually be on your neighbor's property. If you have completed the necessary studies for your property, you should be able to answer these important questions. Are wetlands or other waters present? Are there any riparian areas adjacent to wetlands or waters on your property? Are there any unpermitted improvements in or around any wetlands or waters on your property? Is there a potential that threatened or endangered plants might be present? Is there a potential that threatened or endangered wildlife species might be present? Are there any trees of significance on the potentially impacted area? And finally, are there any cultural or historic resources on the property that may be impacted by your project? Now we're moving on to step 3, preparing your development plan. Once you have determined what is on your property, the next step is to prepare your development plan according to the requirements of each permit you need for the project. At this point, you are likely already thinking about preparing a site plan and a project description for your city or county development permit, which could be a land use permit, grading permit, state coastal development permit, or other similar approval. It is important to also think about potential impacts of the project that need to be considered by those agencies under the California Environmental Quality Act, the National Environmental Policy Act, or similar law if you're outside of California. Now, if your project has the potential to affect any wetland or biological resources that you identified on your property in step 2, those impacts will need to be evaluated, and your conditions of approval will include obtaining permits from state or federal agencies and mitigating for those impacts by purchasing credits or creating those resources elsewhere before you can develop. So in summary, if your development impacts wetlands, your development permit application triggers the need for an environmental review, which triggers the need for a wetlands permit. Therefore, if you want to minimize or avoid a wetlands permit, lengthy environmental review, or document revisions that cost extra time and money, You should try to avoid or minimize impacts when designing your site plan and preparing a comprehensive project description that provides permit reviewers a complete picture of all project requirements and approvals. Remember that agencies will not want to violate the law of another agency. So if you do not provide clear information, they may have unresolved questions that end up stalling your review process. To start your development plan, we recommend first identifying all authorizing agencies and permits that will be needed, and then developing a checklist for required deliverables for each approval. At this point, it is helpful to then cross-reference these requirements to find common tasks to avoid redundant efforts between your team and consultants. Next, you should overlay the boundaries of any water features, sensitive habitat areas, or cultural resource areas onto your site plan to identify where you have any impacts. Once impact areas are identified, you can more easily work with your team to come up with solutions for avoiding or minimizing those impacts to reduce your permit requirements. In some situations, you may be able to request variances to standard permit rules by proposing management plans that eliminate the impacts. For example, if a county requires a 50-foot setback from a stream on your property, you may be able to prepare and implement a stream management plan that reduces the setback in exchange for additional site improvements. Last, we recommend reviewing all improvements in the vicinity of your proposed project to make sure that they are permitted. Similar to a building inspector requiring you to remove improvements in a building that have not been permitted, state and federal agencies will do the same thing if they see grading or improvements in areas that have not been permitted through their own laws. Once you have finalized your impact areas and determined the project is worth the cost, you will be in a good position to prepare a comprehensive project description and any other required documents, such as an initial study or environmental assessment, alternatives analysis, mitigation plan, or landscape restoration plan that accurately depict all aspects of the project, and submit application packages that are considered complete and result in as few questions, comments, or revisions as possible to keep your costs and timelines on track. Now let's walk through the most common permit application deliverables and some strategies for completing them. First, we want to talk about an impacts analysis, or impacts mapping. This engineered site plan on a river shows how important it is to make sure that you complete a delineation of any wetlands or waters and biological study to identify potential endangered species habitat that may be protected before you get too far with your development ideas. We covered in our last step how biologists and wetland delineators are trained to analyze and confirm the boundaries of these areas based on field data. Your engineer and biologist can then better collaborate to come up with better development plans that limit or avoid these areas. Once a site plan and associated impacts are known, most applications start with a project description that addresses all application questions and provides agencies with an accurate overview of the project. Project descriptions need to be detailed because they act as entitlement documents for your permits and provide the baseline information for any CEQA or NEPA review that is required to obtain these permits. It is important to include all aspects of the project in the description because if they are not approved with the permit, you may not be able to complete the project with a modification if agency staff become aware of the missing analysis. Accurate project descriptions need to describe more than what you are doing. They need to clearly define the location, discuss existing environmental conditions of the property, review all applicable regulations, provide a timeline for construction, discuss your project impacts, and finally propose mitigation measures that avoid or mitigate these impacts. The next document that we are covering is the alternatives analysis. Projects that result in wetland or biological resource impacts may require this document for state and federal permitting, which is intended to find alternatives that reduce impacts or explain why less impacts are not feasible. The Army Corps requires an alternatives analysis under Section 404b1 of the Clean Water Act if a project does not fit under the requirements of the nationwide permit program, which we will discuss later. This analysis is similar to and satisfies the NEPA alternatives analysis review requirement. In California, the Water Board also requires an alternatives analysis for any project that impacts more than 1/10 of an acre and requires a more intense analysis as the amount of impacts increase. Alternatives analyses may require analyzing as many as 4 to 5 different alternatives for your project, depending on what sort of details are involved and what the level of impacts are, including a no project alternative discussing what happens if the project doesn't happen at all, a least environmental impact alternative, an offsite alternative, and of course your project. The goal of the alternatives analysis is to identify feasible project options and discuss which ones would be least environmentally damaging, known as the LEDPA, or the least environmentally damaging practicable alternative. If your preferred project has been well planned, it will either result in the least amount of environmental damage or demonstrate why it is the only feasible alternative that justifies the impacts. We suggest the following strategies for completing an alternatives analysis. First, you want to focus on avoiding or minimizing impacts as much as possible, as this will lead to your least environmentally damaging practicable alternative. Second, if impacts are unavoidable, explore all your options, as the analysis needs to include a comprehensive discussion, and this information may be useful for forming the other alternatives. And third, save any information you generate to avoid redoing research later. Now, if you've gotten this far in our webinar about wetlands permitting, chances are that you are at least considering purchasing or developing property that would result in temporarily or permanently impacting wetlands or other waters. The U.S. Army Corps of Engineers requires completion of a mitigation plan template to approve projects with temporary or permanent impacts, particularly if the mitigation includes on-site creation, enhancement, or restoration of wetlands or sensitive habitat areas. The mitigation plan basically provides the instructions for implementing the mitigation for your project once the permit is approved, and therefore needs to match the project impacts. The goal of the mitigation plan is to end up with no net loss of wetlands as a result of the project. Mitigation options include off-site mitigation banks where you can purchase credits, in lieu fees that you pay to the National Fish and Wildlife Fund, or on-site mitigation. The mitigation template required by the Army Corps of Engineers contains 12 sections that provide the agency with details about your mitigation proposal. The sections include a discussion of your objectives, site selection factors, an explanation of the site instrument that you're going to protect the area with, such as a deed restriction, a description of the project baseline information from your project description, calculation of the amounts of mitigation credits needed for the project, a description of your work plan to complete the mitigation, a description of your maintenance plan once the project is complete, details on performance measures that will be reviewed during monitoring, such as the percent of cover of native plant species, monitoring requirements, your long-term management plan, any adaptive management options, and finally, a description of the financial assurances that the agency can rely on to make sure that the project actually is implemented. The preferred mitigation for any wetlands permitting project that results in permanent impacts is the purchase of mitigation credits within the same watershed. This approach assures that the Army Corps that the wetlands or waters that have been adequately replaced are in the same hydrologic drainage area as your project. If mitigation credits are not available, or if the project results in temporary impacts, on-site mitigation in the form of establishing new wetlands or waters, or restoring features that used to be on the property, or enhancing existing features may be the next best option. On-site mitigation is a great option, but agencies are often skeptical that permittees will not be successful and often require more than 1 acre of mitigation per acre of impact, sometimes as high as 5 acres to 1, as well as very stringent monitoring requirements for up to 5 to 10 years of installation. Now we're going to move on to step 4, submitting your permit. The next step in obtaining wetlands permits for your project is to submit applications to the agencies from which you need approval. In step 2, we covered how to determine your permit requirements, which involves reviewing the application forms and instructions, as well as the laws that govern them, and then screening your project by asking specific questions such as whether the project footprint falls within or near a wetland or other water. Our starting point in submitting applications is to understand why they are needed in the first place. The intent of a permit that allows you to impact a wetland, stream, or riparian area is to make sure that your project either has no impact or compensates for those impacts so that the result is that there is no significant loss. It is therefore important to take the application process seriously if you want to get approved as quickly as possible. That means making a diligent effort to preparing a complete application that answers all agency questions. Anything less can result in a deficiency letter. Now, it is common to get some form of a deficiency notice after submitting your application, but it is important to understand that if your application answers the required questions in detail, oftentimes a notice is simply a way for overworked staff to clarify the facts as quickly as possible. The most important thing to do is to submit a complete response, as incomplete information will result in further comment letters and aggravated staff. In the worst case scenario, your application could get rejected if you do not respond or respond inadequately too many times. Your workflow should include the following steps to make sure that your application is successfully submitted and processed. First, you want to review any application checklists or template forms provided by the agency. Sometimes you may be required to submit your application through a portal that asks you a series of questions that you can research as you go. Once you are comfortable with the application requirements, you should next schedule a pre-application meeting with the agency if they allow it. The Army Corps of Engineers and the State Water Board both require a pre-application meeting as part of their process for accepting applications. Other agencies, such as the California Department of Fish and Wildlife, require an application to be submitted with a fee before they will discuss your project. The pre-application process is your time to discuss your project with staff, but it is important to be informed about what they are looking for and even have draft documents for them to review. Depending on your division or region, you may be given specific instructions about what to submit for the pre-application meeting, or it may be more general. At minimum, you will want to be able to explain and quantify your project impacts and how you will mitigate for them. Staff will then provide more specific direction, but will expect you to prepare and submit completed documents on your own. A wetlands permit with the Army Corps will at minimum include a project description, impacts mapping, mitigation plan, biological study, wetland delineation, cultural resources assessment, and a signed application form. You may also be required to submit a hydrologic study, alternatives analysis, or focused biological surveys before your application will be approved. Once you submit your application, you should expect staff to ask questions for clarification or to point out gaps in your application. After submission, your job will be to monitor progress and respond as completely and quickly as possible until all questions have been resolved. The basic strategy for completing applications is to understand that agency staff have limited time and typically a stack of applications to review. The more clear, complete, and concise your application is, the faster it will be reviewed and approved. You should also make sure that you check in with staff at least once a month and do not expect them to reach back out to you. We have discussed how the Army Corps issues permits for activities regulated under the U.S. Clean Water Act. The limit of their jurisdiction is the ordinary high water mark of any flowing water or the delineated edge of a wetland that is connected to a navigable waterway. Performing work in these areas without a permit can result in hefty fines, and additionally, local and state agencies will want to see the permit before they issue their own approvals. You will need to first identify your local district and then determine the appropriate permit to apply for. The options include a regional general permit, nationwide permit, letter of permission, or standard permit. Once you have selected the appropriate permit for your project, you will need to download the correct form and compile the application requirements before submitting. Regional general permits are pre-approved permits for a region or district to streamline approvals. Examples include municipal waste discharge for cities and counties, as well as emergency permits for private property damage. Emergency permits can be approved in 1 to 2 weeks, but are not allowed if there are potential impacts to federally listed species or protected cultural historic resources. Nationwide permits are also pre-approved every 5 years for the purpose of streamlining projects that incur small impacts. There are a total of 59 nationwide permits that cover a variety of project activities, such as residential or commercial development, infrastructure, bank stabilization, dredging, restoration, and more. However, your project must meet the conditions of the specific nationwide permit to be approved. Letters of permission are for projects that do not comply with a nationwide permit or regional general permit because of the conditions, but typically have a smaller amount of impacts than a standard permit. Letters of permission are a lot like a nationwide permit, but do take a little bit more time to prepare, mainly because an alternatives analysis is required. If you remember, we discussed alternatives analyses in step 3. If you don't remember, it may be a good idea to review that section, but basically an alternatives analysis helps the Army Corps determine whether your preferred project is the least environmentally damaging alternative that also meets the purpose of the project. Finally, standard permits are the most extensive type of approval the Army Corps issues under Section 404 of the Clean Water Act, and it is reserved for projects that have significant impacts that are outside the limits of what is allowed under any of the other permits. For this reason, standard permits require a public notice to property neighbors and the public, as well as the alternatives analysis we discussed earlier, and an environmental assessment or even an environmental impact statement in compliance with the National Environmental Policy Act. Standard permits typically take longer to approve and are considered discretionary, meaning your individual approval is dependent on whether the district engineer agrees with your proposal, rather than following predetermined rules like the nationwide permit. Developing a permitting strategy for your project needs to include an understanding of how the Army Corps works as a federal agency and how they collaborate with other agencies. Federal agencies do not need to comply with state or local laws, so federal laws and the rules that they make about how to obtain a permit are the baseline requirements for your project. State and local agencies will not put themselves in a position where their approval conflicts with federal law, so they will want to have confirmation that the Army Corps does not claim jurisdiction over your wetlands or that you have an approval before they will issue a permit from their own agency. Another factor to think about with the Army Corps is that the agency must consult with the U.S. Fish and Wildlife Service if there is a potential that your project might affect a federally listed species under the Endangered Species Act. This process can take 180 days or more if there are incomplete notices, so it is important to plan ahead and submit a thoroughly detailed biological assessment. The Army Corps also must consult with the State Office of Historic Preservation if there is a potential that your project might affect a culturally or historically significant resource, which can take up to 120 days. As these time-consuming consultations ultimately add up to about 9 to 12 months or more to process a wetlands permit, and also will need to be coordinated with your city or county entitlements, we recommend starting this process with your initial map or land use application early. Now we're going to turn our attention to the Section 401 of the Clean Water Act and the Water Board. Section 401 of the Clean Water Act requires permittees who obtain a permit under Section 404 to impact a wetland or water to also obtain a water quality certification. The federal government, aka the U.S. EPA, transfers some or all of these responsibilities of issuing a water quality certification to the state agencies. And in California, that state agency is the State Water Resources Control Board and the 9 regional water quality control boards. The California Water Board is also charged with issuing waste discharge permits or waivers required for state legislation called the Water Quality Control Act. This law was approved to ensure water quality protection for waters of the state. In practice, this law covers wetlands and other waters that are not covered by federal law, such as riparian areas and isolated depressions. To get an approval from the Water Board, you need to first complete a pre-application meeting with their staff who will want at least some preliminary information, such as an impacts map or a project description and a biological study. The Water Board will want to know if you have completed a meeting with the Army Corps and submitted an application yet. If you haven't, you will need to do so before they will accept your application. If your project is an emergency, you will need to apply for a regional general permit instead of the standard waste discharge form. When working with the Water Board, it is important to keep in mind that all waters of the U.S. in California are also known as waters of the state. However, you may also have wetlands or other waters on your property that are considered waters of the state, but not waters of the U.S. Therefore, you want to make sure that you perform a wetland delineation that examines both waters of the state and waters of the U.S. so that you know exactly what you need to do for your permits. The Water Board also requires that your project is compliant with the Environmental Quality Act. This compliance is usually tied to your city or county development permit, and that government acts as what is known as the lead agency. So you will want to have your local development permit well underway before you submit this application. Next, we're going to talk about the California Fish and Game Code and the Department of Fish and Wildlife that issues permits under it. The California Fish and Game Code authorizes the Department of Fish and Wildlife to protect these state resources by issuing lake and streambed alteration agreements for any projects that might affect a lake or stream where fish and wildlife may be living or depend on. The CDFW is also responsible for protecting plant and animal resources that are protected under the California Endangered Species Act and work really closely with the Water Board. If your project affects a lake or a stream or the riparian area near one of these features, you will likely need to obtain one of these permits. The CDFW has an online portal system called ePIMS, or the Electronic Permit Information Management System, that you can use to complete an application, submit it, and track its progress. Additionally, you will upload all supporting documents with your application, so no hard copies are needed. You will need to determine what region your project is located in and what type of agreement or permit you are applying for. Most projects will require a standard agreement, but if you have an emergency, you may qualify for the shorter and easier process called the emergency agreement. You will then need to complete the application questionnaires and upload your required supporting documents, pay the fee, and submit the application. The CDFW has 30 days to review an application for completeness and an additional 60 days to issue a draft agreement. Otherwise, the application is approved by operation of law and all requirements noted in your application must be followed, but you are basically approved. As mentioned earlier, the CDFW collaborates extensively with the Water Board, so most likely you will be working with both agencies on your project. They both need a CEQA determination to issue an approval, so it is best to at least start a development application with your city or county and trigger the CEQA review process before submitting the LSA notification. Both agencies, the Water Board and the CDFW, are required to issue state approvals for complete applications in 90 days. However, the Water Board is also required to approve or deny an incomplete application within 90 days, or it will be automatically approved. The CDFW is not required to process incomplete applications, so it is less important to wait for a CEQA determination to be completed before submitting an application. You will, however, receive an incomplete notice from the CDFW if you do not have a completed CEQA document. Next, we're going to cover Step 5, Negotiating Permit Conditions and Mitigation. Once an agency has reviewed your application, they will prepare conditions that you must follow when the permit is issued. Some conditions are standard for everyone, while others are specific to the project and the situation. If your project results in temporary or permanent impacts to a wetland or other water, or if your activities cause an impact to a threatened or endangered species or protected historic or cultural resource, you will likely be required to mitigate for this impact. Your application should address your impacts and propose your desired mitigation. You may want to go back and review the mitigation plan section that we went over earlier if you need a refresher. Once agency staff have had a chance to review your proposed application and your mitigation, you will then have the opportunity to discuss your proposal as well as any counterproposal from the agency and possibly negotiate a better option for your project than otherwise could have been. Standard conditions are always included in the permit you are issued, and everyone must follow them, unless there are exceptions. In contrast, special conditions may also be included that are specific to your project. Some examples of special conditions include pre-construction requirements such as biological surveys and reports, construction monitoring and reporting by a qualified biologist or an environmental professional as you are completing the work, post-construction reporting after the work is completed, and long-term monitoring for projects that include restoration components or some other aspect that agencies need to monitor as part of your mitigation. Agencies will not deviate from established standards, but there's room usually to negotiate the methods and process required, as well as how often monitoring is needed. You will have the opportunity to discuss any specific conditions and negotiate more favorable terms for your project, such as less surveys or authorizing a qualified biologist to make decisions on the site rather than agreeing with written restrictions. If your project results in permanent impacts, you may be required to purchase credits from an approved mitigation bank within the watershed or your project is located in. These banks have obtained permits themselves to create and preserve wetlands and other waters, as well as habitat for threatened and endangered species. They are set up to sell you credits until they run out. If mitigation credits are not available, the permitting agency may allow you to pay a fee to the National Fish and Wildlife Fund. However, this option may not be approved as it would result in a net loss in the watershed. It is therefore important to talk to agency staff early in the process to make sure that you understand what they will approve on your project. If it is possible to restore, create, or enhance wetland or other resources on your property, you may be able to obtain approval for on-site mitigation. However, this option will require extensive site preparation, construction, and monitoring, and an agency will need to be convinced it can work. Additionally, agencies may require double, triple, or more mitigation to increase the chance that there at least will be some of that installation that is successful long term. Our recommended strategies for making sure that you end up with the best deal possible include making sure that you clearly identify your impacts as noted in previous sections, including the specific type of mitigation needed. Then review and screen approved mitigation banks in your area to see what credits are available and how much they will cost. If no mitigation credits are available, discuss other options with agency staff during the pre-application meeting, including the in lieu fee program. Finally, determine whether it makes sense to complete on-site mitigation based on your site design, long-term use of the property, cost to construct and maintain, and the viability of creating successful on-site mitigation that lasts and exhibits performance metrics identified in your mitigation plan. Step 6. Complete construction monitoring. Construction monitoring is always required by permitting agencies to make sure that the work is performed according to the permit conditions. A qualified biologist is usually required to conduct the monitoring, which can be very minimal or intense depending on the project and the potential impacts. The biologist conducts the monitoring in 3 stages. The pre-construction survey is needed to review the site before construction to make sure that there are no special status species present, flag wetland areas, and other permit requirements. Next, depending on how the sensitive area is constructing, Next, depending on how sensitive the area is, construction monitoring may be required to make sure activities do not impact any sensitive areas or hurt or kill a special status species. Once construction in the wetlands or other sensitive area is over, a post-construction inspection and report may be required and includes compiling survey notes and submitting a report with a compliance certificate to the agencies involved, usually the Army Corps of Engineers. Reports may or may not be required at each stage, but they are always required when the work is finished to close out the permit. As the work is reviewed by staff who can make unscheduled visits, it is best to make sure that you are following your conditions and mitigation requirements at all times. You should first review the permit conditions and make sure that any work on site follows them. If your project involves dewatering, concrete installations, or other activities that could cause harm to the environment, you will likely have specific conditions that will require the site to be prepared first. Complete these preparations and then contact your biologist or wetland permitting consultant to schedule the pre-construction survey. A biologist is usually required to survey the construction site for any sign of special status species that were evaluated during the permit process. The permit will include mitigation measures for each species that are intended to avoid impacts when followed. Examples of mitigation measures for biological resources include endangered species area fencing, which is basically construction fencing, covering any holes or hollows that have been inspected for animals, netting bridges, rafters, or other areas that might be attractive to bats, etc. Some good strategies for handling pre-construction surveys include talking to your biologist about combining survey requirements to avoid multiple trips and taking good data, including photos that can be used for reports later. Oftentimes, reporting is inhibited by how much or the lack of data that has been collected in previous surveys. It can also be helpful to talk to your consultants about how they can share the data, such as aerial photography and topography, to reduce time and cost. Make sure that you have your records ready for an inspection, including your permit conditions, mitigation documentation, and your monitoring records. Depending on the specific details of your project, you may have very minimal monitoring and reporting requirements, or they may be very stringent and require you to hire one or more consultants. These requirements may include terms you negotiated with the agency. Make sure to review your requirements in detail. Often a biologist will be required to observe the removal of any vegetation in the work area if there is a potential that there is a threatened or endangered species that might be there. Once vegetation is removed and any dewatering devices are set up and working properly, biological monitoring requirements should be more minimal until the construction is complete. Construction monitoring is expensive and may seem like a waste of time and money, and sometimes it is. It is important to make sure that you negotiate for the best possible monitoring deal when an agency approves your permit. For example, you may want to be able to reduce the number of times that the biologist needs to visit the site, because each time costs you money. Another way to reduce your costs regarding monitoring is to use someone who is already on the site, such as a supervisor who is cross-trained to report to the biologist of record for the project. Once construction is completed, the biologist of record should complete a final survey of the area to make sure that all materials and equipment are removed, including protective fencing. The biologist will also look for signs of erosion and sediment controls that protect the permitted area and any future impacts. Once the survey is complete, the biologist or permitting consultant will compile a report that includes verification that the project is in compliance with all required conditions and mitigation. Many permittees forget to submit their certificate of compliance or other required document to finalize a permit. Incomplete permits can lead to issues in the future when you or someone else proposes another action in the area. In the worst case scenario, the work may need to be re-permitted or mitigation areas may need to be reinstalled. Make sure that your conditions and mitigation measures are completed and that you keep a copy for your property records. Now let's move on to step 7, which involves complying with long-term management requirements. The Army Corps and any other agencies that issued your permits may require long-term management solutions. If you have installed any on-site mitigation, your permits will likely require you to monitor the success of that installation for a period of time, with a minimum of 2 to 5 years. Most often it is 5 to 10. For more complicated installations, it could be even longer, even into perpetuity. You will likely need to have a biologist complete this monitoring for you, but you will be responsible for ensuring the installation works as it is intended. You will want to make sure that you review your permit conditions and mitigation measures, and then talk to a biologist or your permitting consultant to develop a management plan and a schedule for long term. Make sure to include performance maintenance work according to your requirements, or hire someone to do it for you. Maintenance activities may include pulling invasive plants, revegetating areas that have been damaged, fixing fences, and managing plant growth for fire suppression. Since you will be responsible for complying with the permit conditions and mitigation measures, it is important to set up the right team from the start. Poor communication and lack of foresight, such as planting replacement plants at the wrong time of the year or not caring for them correctly, could cost you much more than your original budget. Now we're going to move on to some case studies that we have put together for you to kind of give some examples of how these permits are put into action. I have included a project with no wetland impacts, one with temporary impacts, one with permanent impacts, and then one that has no federal wetlands at all, but does have federally listed species. Our first case study involves a residential community that we permitted in the city of Santa Cruz, California. The property is located adjacent to the coast and contains 3 ponds that are irrigated from a well that flows into the Pacific Ocean. The ponds are considered jurisdictional waters under the U.S. Clean Water Act, as well as the California Water Resources Control Act and the California Fish and Game Code. Additionally, the project is within 100 feet of the coast, and so means it is also regulated by the California Coastal Commission. Proposed improvements in 2022 included repairing the pedestrian bridge that extends over the ponds and replacing and repairing some of the retaining walls along the edge of the pond area. A wetland delineation and biological study were required to confirm that the project would not affect the ponds, as well as any threatened or endangered species. Our resulting report and permit concluded that the work would not affect the ponds, so no wetland permitting was needed, and we also researched approximately 75 species that could have the potential to occur at this location, given that it is in a sensitive area and next to a state park. We then prepared mitigation measures or best practices for avoiding any special status species when the work was performed. Most significantly, our client had to wait until after April 15th to start work to avoid monarch butterflies and the giant garter snake. Our next example is an RV campsite and resort in Acton, California. A river crossing was built in the 1970s without permits that has been repeatedly damaged by flooding. The property owner proposed to fix the crossing in 2018, but agencies requiring the crossing to be removed or replaced with a bridge that allows water to move more freely. The Santa Clara River that flows through the property is considered potential habitat for more than 50 threatened and endangered species, including 9 federally listed species. However, the river is dry most of the year, but experiences floodwaters that can flow at a maximum of 30,000 feet per second. Delineation of the riverbank and adjacent riparian areas included hydrology and hydraulic analysis conducted for bridge design and extensive biological analysis to confirm that no protected species would be affected by the project. We ended up with 2 permitting actions. The first, to temporarily fix the impoundment while the bridge was designed to allow for vehicle passage, and the second, to install the permanent bridge. Both rounds of permits were eventually approved and construction was completed between 2022 and 2023. Our next example involves an agricultural property in Lincoln, California. The developer proposed to construct 153 single-family residential houses. The city of Lincoln required a biological study and a wetland delineation to approve the project, which revealed that the property contained wetlands in the agricultural field, as well as roadside ditches around the perimeter. The wetlands on the property were also assumed to be habitat for federally listed species, including the vernal pool fairy shrimp and tadpole shrimp. We prepared a delineation of the wetlands and ditches on the property, as well as a biological study to determine mitigation requirements. We then applied for and obtained a nationwide Permit 29 for residential projects with the Army Corps of Engineers and the California Water Board, which involved negotiating and purchasing mitigation credits at an off-site bank, as well as on-site conservation by modifying the site plan to avoid additional impacts. The project was approved and mitigation credits were purchased for impacts, along with completion of a 5-year monitoring plan for avoiding wetlands. Our next example is a commercial property in Elk Grove, California. The property owner owns the building on the adjacent property and wants to expand it by building an additional 401,000 square feet of building. The city requires a wetland delineation and a biological study to approve the development permit. The property is adjacent to wetlands and other waters and was mass graded in the 1930s, so nobody thought that there were any wetlands on the property. However, it is now home to several areas that are ponding water during the winter and are considered jurisdictional wetlands. Additionally, there is potential habitat for vernal pool, tadpole, and fairy shrimp, which are considered federally listed species. And now, because wetlands are isolated, no federal wetlands permit may be required. The question is, how do we mitigate for federally listed species? To answer this question, we completed dry and wet season surveys for tadpole and fairy shrimp to determine whether they actually had presence on the property. We then processed a preliminary jurisdictional determination of wetlands through the U.S. Army Corps of Engineers and are currently working on obtaining a waste discharge permit from the California Water Board. We are also working with the Army Corps and the U.S. Fish and Wildlife Service to determine what permitting action will be needed on the property, either an Army Corps permit or a Section 10 incidental take permit through the U.S. Fish and Wildlife. Dry and season surveys revealed smaller pools within wetlands that are considered habitat, reducing impacts and requiring mitigation. So basically, we were able to reduce the amounts of habitat mitigation required for the property by conducting our dry and wet season surveys and reducing the total amounts of mitigation required by the project by up to about 2 acres. Mitigation for permanently impacting federally listed species needs to be permitted directly with the U.S. Fish and Wildlife Service and can cost up to $250,000 to $300,000 per acre. So this is a really important thing for our client, and we are still working through processing the outcome. That concludes our webinar for today, covering 7 critical steps for managing wetlands permitting for development projects. We hope you enjoyed our presentation and learned a few strategies that will help you obtain the approvals that you need for your next project. Thanks for watching.